welcome to my live show. Viewers, I'll speak today about child arrangement order or child contract order. Although most of the time, most of my live session, I speak about immigration case, immigration update, and I give answer on immigration. But today I'll give some information about child arrangement order and how it is important for immigration cases as well. I'll speak who can make child arrangement order or child contract order under Section 8 and how to make the application and what someone will achieve by making a child arrangement order. This is a family law update today. Solicitor Suhalas, I will be with you next couple of minutes. If you have any question, please feel free to speak with me. You can call me, the number on the screen, and I'll give your answer. So child arrangement order, basically a application to the family code to make a decision with who the child will live. The child arrangement itself suggests that the arrangement for the children. So if you have an issue with the child, you can make an application to make a decision by the court with who the child should live, with who child should spend time, who will look after the child, who will take the child to school, with who the child will spend time on a weekend. That's what all about it. This now, who can make the application? Anyone who have a parental responsibility can make an application for child arrangement to the family code. Now, parental responsibility is something very important, and I think you need to understand. Not everyone have a parental responsibility. Mostly parents whose names in the birth certificate, they will have automatic parental responsibility. If the parent name is not in the birth certificate, or someone has name not in the birth certificate, then you can other way you can achieve the parental responsibility. For example, in order of the code, enter into an agreement with the child mother. This is how, by adoption, this is how you can make a child parental responsibility. If you don't have parental responsibility, still you can make an application to the court, but the permission will lead to code of permission will be required. So you need to make an application for permission first to bring a child arrangement order, and if that would give you permission, then you can make a child arrangement order. But if you have a parental responsibility, that is your name on the child birth certificate, you will have automatic right to apply for child arrangement order. The procedure, how you can make the application, is mostly very straightforward. That is, you need to fill up an application form, which is called C100. You can download it from the government website, Haitian Court and Tribunal website, and download it, fill up the information, mostly basic information, that is regarding your child, their name, their date of birth, your address, your partner or your wife's or husband address. So this is all about it and what order you are seeking. So that what you need to make an order. So when you fill up this form, in the form you will get a couple of options. For example, you can apply for child arrangement order, you can apply for a specific issue order, you can apply for occupational order. So different kinds of order. So it depends mainly if you're just looking for that you want to see your child, or if you want your child to stay with you, then you need to make a child arrangement order, that is Section 8 order. If there are any specific issue, which, for example, if you seek an order that you don't want your partner to take the children out of the UK, then you should choose a specific issue order. Or, for example, if there is an issue to change a child's surname, then you can choose a specific issue order. And also with the application form, you need to prepare and give a statement as well why you want to seek this order from the family code. And then you can send it to the family code. If you can, the application fee is £215. Either you can send, you can give your card details, or you can send by a check. If you are on welfare benefits, certain circumstances, you could get exemption from paying the child arrangement court fee. Now, the child arrangement order is a bit lengthy process. So once you make the application to the family court, the court will first give a first dispute resolution hearing appointment, and then dispute resolution hearing, then dispute resolution hearing again. And within this time, the court will try to resolve this matter without going to trial. Before make this application, it is mandatory for the applicant to apply to go to a mediation process for your child, so that the court, so the court wants the both party give their full effort to to try to solve this issue without going to court. And if the mediation fail, conciliation fail, then the conciliator will issue a certificate, and that's what you have to produce to the court. But there are some exception, that is if there is domestic violence issue involved, or there is a risk of safety, or if you go to the mediation, then within this time, the other party will remove the child from the UK. So if it is some kind of exceptional or emergency situation, then you don't need to go mediation. You can straight away go to the court. You can also apply for emergency child arrangement order by within 48 hours or within 2 hours notice, or without notice. That is, if normally what happens if any applicant come to our office, if it is emergency situation, we straight away take our client with us. We go to the court, ask the clerk to make an appointment, emergency appointment with the judge. We go to the judge chamber and then take the order emergency without notice. So this is how it works. And then we take the order, give the respondent one copy in the police station. This is how it works. Now, once you get the decision, the family court, you can carry on. In the meantime, if you are not happy, you can again come back to the court again. If the circumstance has changed, then you can tell the court to set aside your case or child arrangement order. This is a brief information about child arrangement order, or it used to be people call it contact order under Section 8. Some people call it Section 8 order. Now, how it is important for immigration cases. Now, many people, when they get married or form a partnership, they got children. Unfortunately, the relation is not good. Well, they're separated. Now, the person who is a non-UK national, he maybe rely on visa, his partner. Now he doesn't have any sponsor. So what is his remedy? He has a child in the UK, so he have a family life. He have a life with his daughter or son. Now, if UK authority decide to remove him from the UK or deport him, then he will be deprived from his from the daughter. Daughter will be deprived from his or her fatherhood. So what you can do, if you want to make an application on the basis of your private and family life, first you need to prove to the Home Office that you have a family life with either with your partner or with your child. As you are separated from your partner, so you cannot use your partner details, for example, her passport, but maybe your child is living with her mother or with other partner who is a British national. So first, you need to prove that you have access to your child. So you need to make an application to the family court for contact order or child arrangement order, that is C100 form, and you need to fill up this form with supporting evidence. Once the court make an order, that is, for example, court will give an access to your child every weekend, you will take your child in your home, you will spend the weekend, and you will return back on Sunday to her mother or her father. Alternatively, court can give order that you will take the child on every Sunday or Saturday to a contact center under supervision. You will see the child. So these types of order normally family court issue. Once you get the order, then now you have access to your child. That is the court order. You have a family life with your child. So you can use that court order as evidence of your relationship with your child. Alternatively, although you are separate, you will be required to pay the maintenance for your child. Now, child maintenance is not deal with the court. This is a child's CSSO, which is child service agency, child maintenance agency. They will separately, they will deal with this. So normally the agency will contact with you, and from your national insurance, they will track and trace you, and then you need to pay the maintenance. Again, if you pay the child maintenance, also you can use that proof of your payment as a relationship with your child. And again, when you make the application, leave to remain on the basis of your family life with your child, you need to provide evidence, the court order, you need to provide evidence of your child maintenance. It is advisable that if you can, and if the child mother or father agree, who is a UK national, to give a written letter that you pay the child maintenance, you have access. But most of the cases, other partner refuse, from my experience. In that case, if any social care involved, you can take a letter from the social care as well. Because when you apply for child arrangement order, the court will give court will give order to the social care, to the local authority, social care to look at this, whether it is necessary to make any care proceedings or arrangement. Court will give order CAFCAS to prepare a Section 7 report. Court will give order children agency to make a Section 37 report. So this is all of the agency will work. And if you receive any correspondence from this agency, if they give you access, all of this information, all of the document you can use as a relationship with your child. Remember, your relationship with your child must be a relationship for love and affection. You shouldn't apply to the court order just to secure your visa in the UK. Because if your purpose is just solely to get a visa, unfortunately, Home Office or Court of Appeal take it very negatively. And a court decision I told last week that Court of Appeal in many cases told this, that you cannot use your child as a trump card to get visa in UK or leave to remain in UK. So it is important for the father or the mother will apply for child arrangement order. Your relationship with the child should be a genuine relationship for love and affection, father and mother, for a family relationship. And if you can establish these types of relationship, then you can get leave to remain. Thank you very much, viewers. This is a brief about family law update. I'll back to my immigration case regarding different update. If you have any question, please feel free to call me on the number at the screen, or you can leave a comment and I'll give you an answer. So today I received a couple of emails, and among this most important email what I have received about adult family member. What I discussed yesterday, that house British national or EU or the people settle in the UK can bring their adult family member. I'll not give this answer today. So if you need to know about how can you bring your parents from outside the UK permanently in the UK as a British national or settle in the UK, please go back to my last video and you can watch it over there. But what I'll speak about this is important for a lot of people who make comment on my Facebook about asylum. I'll speak how someone can seek asylum. If any asylum application refused, whether someone can make fresh asylum claim. Secondly, I'll speak the hope for undocumented migrant about amnesty from the Prime Minister. At the same time, I'll take question. If you have any question, leave the comment below or you can call me. So first, how someone can make asylum. In UK, someone can make asylum by two ways. Once, when your plane is landed at the airport, or if you landed by any other port, as soon as your plane is landed, you can meet the immigration officer, and for example, in Heathrow Airport in Tech-Up, and you can ask the immigration officer that I want to seek asylum. And the immigration officer will arrange your interview as soon as possible. Normally, within 2 to 3 hours, they will arrange in your interview. This is called screening interview. Screening interview is mainly to identify who you are and where you're coming from, how you travel. They will ask maybe 1 or 2 questions why you want to seek asylum. But screening, the sole purpose of the screening interview is to identify you, who you are. And then after the screening interview, most of the cases, they will let you go. Probably if you need any accommodation, you can ask the immigration officer or the caseworker that I don't have any place to go. They will arrange you a hotel or somewhere to stay. After the screening interview, probably they will give you an ARC card or some other paperwork. They will take your interview in some form of paper. They make sure after the interview that they will take your signature. Most of the applicants, they are under stress and they cannot or they don't have any opportunity to read this paper what they say. But it is very important and it is advisable that when you sign any paper with whether police or immigration officer or immigration case worker or anti-clearance officer, before signing that document, make sure you read every single question, every single answer what the case worker write on this paper, whether it is in first interview or substantial interview, screening interview or substantial. If there is a blank anywhere below any question, you ask the caseworker to give a cross on the blank, because once you sign it, then if this document can be fabricated if something left blank. So make sure, read the question, read the answer, there is no blank anywhere left, and then you can sign it. You can do it politely, request the caseworker, and he will be happy to do it. Now, this is the how you can ask asylum at the home. If you are already in the UK, then there is an asylum helpline appointment phone number available at home office website. You can call this number, make an appointment with them, and just you tell them that I want to seek asylum, so they will give you an appointment. Probably they will take some information over the telephones, that your name, your date of birth, and they will give you an appointment. We'll go to the appointment and they will take your details. That is again who you are, where you come from, how you travel to the UK. Maybe 1 or 2 questions they will ask again, why you want to seek asylum. That is all about screening interview. After the screening interview, most probably within 6 months or within a year, you will be invited for a substantial interview. By the way, in the meantime, after your screening interview, you can ask the Home Office to give you a permission to work. And also, you are eligible to apply for public funds. That is, you can make an application to the Home Office to give you accommodation. Also, you can apply for financial help. There is a form available in Home Office website. So you can fill up this form, send it to the Home Office, and the Home Office will give you 37 pounds per week for each person in your family. If you have more than 1 person, for each person you get 37. In addition to the finance, you also can apply to the Home Office to give you suitable accommodation. Now, Home Office either will provide you a hotel if you are a single person. If you are a family with child, that normally refer you to a local authority or a charity, they will arrange you a suitable accommodation. So after your screening interview, you can apply for financial help to the Home Office. You can apply for accommodation. At the same time, you can apply for work permit. And the Home Office, majority cases, issue the work permit. Now, if you get the work permit while you are on asylum, you cannot do all types of job. There are some specific types of work which is at shortage occupation list. That is including work in a restaurant if you are a chef. So these types of work you will eligible to work while you are on asylum. After the screening interview, after I said about 5 or 6 months, later, or highest 1 year later, you'll be invited for substantial interview. Now, whether you are seek asylum at the airport or Dubai, or you seek asylum from inside the UK, a substantial interview will be the same procedure, and it is very important for asylum seeker to seek legal advice, to collect evidence before substantial interview. Because substantial interview, I said, is the backbone of your asylum claim. If you can give right answer, if you can convince the caseworker, if at substantial interview, your application will be successful. You will get asylum. But majority applicant, they don't seek legal advice, or they don't bother about substantial interview. They become nervous, lack of evidence, lack of confidence, lack of honesty. They fail, and they almost refuse their asylum. Even that some applicant cannot tell their own name at substantial interview. So my advice or my suggestion will be, before you go to a substantial interview, you should consult with a solicitor, with an experienced lawyer about your situation. Because there are plenty of case law, there are plenty of court decision. It basically came from, it come from the Court of Appeal about asylum, human rights, humanitarian protection. According to your circumstance, according to your situation, might be a case law will be relevant, might be a guidelines will be relevant, might be section article 1 will be sufficient enough to establish your claim. So whether you seek asylum on the basis of political opinion, or because of your religious opinion or sexual opinion, or because of your any other reason, membership of any particular groups, so all about is evidence and give the right answer. So first you need to understand the law. If you understand Article 1 of Refugee Convention 1951, you will understand, you will learn 50% of asylum law. Every word of Article 1 of Refugee Convention is a law, and you have to satisfy the caseworker that every single word of Article 1 of Refugee Convention is applicable to you. If you just tell the caseworker or the Home Office that if I go back to my home country, the opposition government or the government will kill me, or they will put me in prison, it's not sufficient. If you tell, if I go back to Afghanistan, Taliban will kill me, it's not sufficient. The first requirement is you must have, you are in the UK and you have a fear in your heart, inside you, that if you go back to your home country, either by government or any agency of the government or any membership on any particular social group or any community will torture you, will unlawfully detain you, will kill you, they will probably kidnap you. Now that will be happen because of your particular belief, because of your political opinion, because of your religion, because of your sex, because of your membership of any particular group. And because of this reason, you have a fear and you are unwilling to go back to your home country. That is Article 1 of Refugee Convention. Now, when you can establish all of this wording, all of this fact, and the fear is not only that you have that fear in your heart that you don't want to go back, you're scared to go back to your home country. This is not the case. The Home Office and the caseworker, while he will interview you, he will try to understand whether you have, genuinely you have this fear. And then the second, he will look at whether someone like you in your position genuinely have this fear? Will someone have this same fear in your position? So when home office caseworkers satisfy that requirement, then you will get asylum and he will give you a positive result. Therefore, I believe it is important for an applicant to speak with a solicitor or speak with a lawyer before go to substantial interview. And another important thing is, before you go to substantial interview, it is important to collect evidence. Evidence is very important because it is the Home Office policy. When you claim something, you must establish it with supporting evidence. For example, when you will give the interview to your caseworker at the Home Office about your asylum claim, you will tell the Home Office, well, Home Office will, for example, two questions is very important. Anyway, I'll back to what question I'll ask. For example, you said that, well, while I was in my home country in 2010, they tortured me, they arrested me, I was in prison, they give fire in my home. So now you tell that story to the Home Office. Now go back to your file. You should take some evidence with you from your lawyer, from the judgment against you that you've been tortured. So police report, a hospital report, any photo that they give fire at your home, any other report from any authority, any local newspaper. So all of this information you should provide to the Home Office. When you will give that, when you tell the story that give fire and show the photo from your file. You will take a bundle of file with you, and when you tell any form of issue to the Home Office, go to your bundle, show them. For example, you've been tortured, so show a photo, show a police report, show a hospital report, a doctor's certificate from your bundle. This is how you can convince the caseworker. Now, everything is practical. It is nothing that you can take a solicitor with you and solicitor will fight for you at the interview. This is not like that. Everything had to be a realistic and practical matter. It is a conversation. Substantial interview is a conversation between you and caseworker. So you need to sit flexibly. You shouldn't be nervous and show the document when you tell the story, when you told an issue, back to your file, give a reference, show a document. If you can prepare like this, and if you can give the substantial interview the way I'm saying, your application will be successful. Your asylum claim will be successful. Viewers, my name is Suhail Ahmed. I'm an immigration and human rights lawyer. I'll back to you after a small break. Viewers, after the substantial interview, probably 2 to 3 months, you will get your decision from the Home Office, outcome of your asylum. If you are lucky, you'll get your decision in your favor. If you are not lucky enough, Home Office will refuse your application. What will be the next remedy? Well, you may get appeal right, in-country appeal right, unless the Home Secretary is certified under Section 94 or 94B. So if the Home Secretary give in-country right of appeal, then you can go to the fast-track tribunal to make an appeal against the decision of Home Office. If you don't get in-country right of appeal, the next option 1, you need to go back to your home country. Option 2, if you genuinely will face a death penalty or unlawful torture or unlawful kidnap, unlawful detention, that case you can go to the court, upper tribunal, and apply, challenge the Home Office decision by way of judicial review. The procedure for judicial review is you must issue a pre-action protocol against the Home Office. You need to fill up a pre-action protocol letter that is available from the government website. You need to download it, fill up it, and then You need to provide a grounds, that is on what ground you are challenging, what ground you are saying that Home Office was wrong to refuse your application. And then you can send it to the GLD, which is Government Legal Department, Home Office, and then they will you will give them 21 days or 14 days time to reply. And within this time, they will give a reply. And again, in this pre-action protocol, sometime Home Office change the decision and give you a positive result. Obviously, this pre-action protocol have to be a professional, try to be explain the law, how the Home Office make the wrong decision. And after that, you can go to court, that is upper tribunal, to make an application to challenge the Home Office decision. First application will be permission for judicial review. If the upper tribunal accept your application, then you will go to the main hearing. If the Home Office refuse, if the upper tribunal refuse your permission to hearing, then you can apply to the upper tribunal for permission to appeal. If the upper tribunal refuse, then you can go to the High Court or Court of Appeal for permission to appeal. This is how judicial review works. But judicial review is a very expensive process. So this is the one way, the next stage remedy for refusal. Other way is, if you think, well, you fail or you fail to secure your asylum claim, or the Home Office refuse you to recognize as a refugee, what are the other available options? I discussed this a lot in my previous Facebook Live. The other available option is you can seek a humanitarian protection. If your asylum claim fail, you can try the next stage is humanitarian protection. If humanitarian protection fail, you can think about human rights claim. Human rights claim is very wide. Couple of ground, on different ground, under different article, you can seek claim leave to remain in the UK. But majority of the people seek a human rights claim on the basis of Article 8, that is private and family life. Private and family life, majority people is take as a simple, but it is not simple. Even if you can claim properly with sufficient evidence, private life basis, your application might be successful, but it need evidence. So when you establish a private life, don't rely, because Article 8 people, majority people is saying only family life with partner, wife, or children, but it is not limited to. If you have a family life with a wider family, with a relatives, with a brother, with your granddad, grandmom, this is also Article 8 rights. If you can establish that you have a genuine and very strong bond with any extended family member, with any relatives, you look after someone, you can make a claim on the basis of your relationship. Now, most of the cases, Article 8 application refuse just lack of evidence. So from my experience, when I give advice, any client, I advise them, well, you have if, for example, someone have a strong connection with the community. So bring some letters from the community, go to the mosque, take a membership. If you have any membership of any club, any charity, any other organization, ask them, give a letter. This is your private life, because family life is relationship with your family member. Private life is relationship with your community, with the organization. If you're a member of any club, cricket club or football club or charity, or if you're a volunteer of a mosque, this will give you an evidence that how strongly you integrated with the UK society. And Home Office take this seriously. If your integration is very strong with the Home Office, with the society, with the English society, English community, Home Office give very importance. So I advise always, because every people who is asylum seeker, he have a strong connection with the community. He's a member, he's a volunteer of the mosque, he's a member of a cricket club, he's a member of a football club. He does a lot of voluntary work in different organizations, charity. So these types of letter, these types of information is very important to prove your private life in the UK. And family life, I already said that you can make establish with your partner, with your children, with your wider family, with your grandmom, granddad, all of these. That is all about Article 8. Now, other than Article 8, you can also think Article 2, right to life. That is, if you fear, if you scare, or if you fear that if you go back to your home country, either government or any government agency or any organization, community, or your own community or your own family, your relatives will kill you, or you'll face death penalty. You can make a claim on the Article 2. Because Article 2, Article 3 is a right which is absolute, unconditional right. If you make a claim under Article 2, and if you can establish Article 2, Home Office will not able to deport you in your home country. Because Article 2 and Article 3, that is free from torture, that is absolute right. Unconditional right. Unconditional right, conditional right. Article 8 is a conditional right. Many people maybe is not familiar with these terms. Conditional right means Home Office can breach these types of right if required for public interest. So Article 8 can be breached. If you have a family life with someone, but for public interest, Home Office can breach Article 8. They can deport you by breaching your family life. But where there is the Article 2 or Article 3, Home Office cannot breach even for public interest. Probably you know Abu Qatada. Abu Qatada was the same issue about Article 2, and they failed to deport him. Finally they take an undertaking from Qatar government, and then they ensure that he will not face death penalty. And after that, they deport him. So this was a big case, but this case was exposed by press, and a lot of background was there. But when you will establish Article 2, Article 3, then Home Office will not able to deport you because of a unconditional right. The next article, human rights, is Article 6, right to fair trial. What is Article 6? Now, Article 6 is a fair trial. Fair trial, basically, if you have any case outstanding, I'll back after a break. So Article 6 is basically, it is if someone have any outstanding court proceeding left, whether family matter, personal injury, employment matter, or immigration matter. And if you left UK, it will not possible for you to get the fair trial. Or, for example, you will be required to give evidence to the court in your personal injury, or in a family case, or in your immigration case. In that case, under Article 6, you can claim leave to remain for the sake of justice. But you need to establish that if you require to go back to your home country, you will not have access to a lawyer, you will not have access to internet. And many cases, it's been successful on Article 6 ground. In addition to Article 8, also Article 6, Article 3, you can combine to make a claim. So Article 8 and Article 6, together you can make the claim. Yours, that's what all about today. I spoke mainly about how you can make the asylum claim, how you can make humanitarian protection claim. If you fail to secure your asylum or recognize as a refugee, I spoke about how you can make application on the basis of human rights under different article. If all of this fail, that is your asylum fail, your humanitarian protection fail, your human rights claim fail, what next? The last resource, further submission. Further submission is if your asylum or human rights claim fail or refused by the Home Office or appeal is refused by the court, then you can, if your circumstance is changed significantly, then you can make an application to the Home Office about yours, that is your circumstance change significantly. That is further submission. General rule is to make application to the Home Office in Liverpool personally, but some exception. If you cannot travel, if you are in hospital, or if for any other reason, if it is beyond your control, you can make application by post. There is a form available in Home Office website. Again, you can download it, write by your pen and pencil. That is not in a PDF format, so you can download it, fill up it, send it to the Home Office. It's very easy. But it is important to seek advice from the lawyer if you want to make your application successful. Further submission, also you can add some grounds with your application. So it's a separate ground on what basis you are making this further submission. Viewers, this is my final update today. I hope all of you enjoy. I'll see you tomorrow again at the same time with some new update. Good night for everyone.